Welcome everybody to our webinar today, covering the topic of casual employment. My name is Wayne Baker. I'm the CEO of Symmetry HR, and I've been at Symmetry since 2011. Just for those that don't know, Symmetry provide solutions in recruitment and HR for businesses nationally across traditional blue-collar sector in manufacturing and logistics. We're also across the white-collar sector in the contact centre space and all office and managerial-based roles. And we're also in the health sector within hospitals and aged care facilities. It's great to have everybody in attendance. We're looking forward to what the webinar will bring today. Just to give you an idea of what to expect over the next 1 hour, we're going to summarise the Rossato versus WorkPac decision. We're going to spell out what it means for employers and employees. We're going to show you what the main risks are for your business. And also we're going to look at what you can do to reduce the risk and still hire casuals. Just a couple of housekeeping matters before I introduce Nick Tinley. All questions are to come through the chat box, including technical and of course topic-based questions. We will address those in a Q&A with myself and Nick after the presentation. We will be drawing from those questions from the chat box that you've provided. So without any further ado, I want to introduce Nick Tinley. So Nick Tinley is a partner with FCB Workplace Law, and he's also the Executive Manager of HR Consulting Advisory Services at FCB HR. He's based in the Melbourne office. He has over 12 years experience in providing industrial relations and employment law advice, with particular expertise in the retail industry. In his role as the Executive Manager, Nick supervises both the consulting and advisory teams at FCB HR and is responsible for managing a number of key client relationships. Nick also manages the advisory services for a number of bodies, including the ARA, which is the Australian Retailers Association, the RCSA, which is our body, the recruitment body, Recruitment and Consulting Services Australia, the Victorian Association for News Agents, and also Fitness Australia. Nick also participates in the Workplace Policy Committee of the Australian Chamber of Commerce and Industry, and facilitates the Recruitment, Consulting and Staffing Association's Workplace Relations Working Group. Nick is extremely close to this industry and government issue. And one could say that today we are getting the inside word. A little bit of a personal thing about Nick. He loves a getaway and he loves Peterborough, which for those of you who don't know is about 3 hours from Melbourne, on the beautiful Great Ocean Road on the southeastern coast of Victoria. So without any further ado, I welcome Nick Tinley. Welcome, Nick. How are you?
Thanks, Wayne, for that lovely introduction. I like the lengthy discussion about all my titles and what I do. It makes me feel really important. Yeah, and thanks everyone for attending. This is a really an interesting topic, this kind of question of casual employment and how the last few years have really evolved our thinking and understanding of the risks involved around casual employment. I remember I've been with FCB for 10 years now, and I remember in one of my early, probably first or second year here, I had a new client come to me, and they'd had an employee who'd been working with them in one of their retail stores as a manager for, I think, about 9.5 years, and a law firm had written to them saying, you know, this employee is actually a permanent employee. They've got a kind of firm advance commitment as to their work, and we had to go through all sorts of work with this client to try to find an argument against the idea that they were a permanent employee, and we were able to do it in part because, and I say able to do it in that we were able to convince the law firm and the individual to walk away from any any claim. But in reality, we did that by kind of assessing their hours over the course of the employment and identifying that they had worked quite variable hours, predominantly because they had a decent level of control over the work that they did. So I said to the client, we're probably at kind of 50-50, 60-40 at best in terms of our ability to defend this if it went to court, but let's put all the work into defending it with the law firm and the individual, and we kind of bluffed our way through it, and the person went away. But that was I think that occurred about a month or two after the McMahon mining case, which was the first of the more recent ones of these casual employment cases, and then it kind of lay dormant for about 6 or 7 years. Skeen and WorkPac came along, and I think that was about 2.5 years ago, and that frightened the hell out of a lot of us, because that was someone who was paid as a casual employee, purportedly paid a casual loading, but was then deemed entitled to permanent employee entitlements under the NES, including the obvious ones of paid annual leave, paid personal leave. WorkPac obviously had a fair bit of exposure around this Rossato, or around this kind of casual employment question, and so they've then had to look at what they can do to minimise that exposure, and in particular in the face of a wide range of class actions that are being instituted. So we can go to the next slide, Gareth. So what we're going to cover off, I'm going to talk a little bit about this full court of the federal court decision. So summarise what it means, identify what the differences are between Rossato and Skeen. I think it's fair to say that whilst factually they're not worlds apart, Rossato's probably cut off some avenues that we thought we might have to avoid some of this casual employment risk. We'll talk in broad terms about what it all means, a little bit about the things that businesses can do to minimise risk, and also just identify where that risk might lie. And then we'll talk about the government response and WorkPac appeal. I need to be a little bit careful about that government response question. I'm on behalf of one of our association clients participating in a working group set up by the government, by the Attorney General, to look into this issue of casual employment. And we're under very strict obligations not to talk about what's happening in those working groups. So I'll be kind of talking about things that are in the public domain only in relation to potential government responses. So in the background of this WorkPac and Rossato is that Skeen came along. Skeen was successful in being deemed a permanent employee, and it led to the commencement of a lot of class actions. As I said, I think there's about 18 class actions live at the moment, predominantly in black coal mining. But Mr. Rossato came along after Skeen and asked for payment of entitlements during his 3.5 years of working for WorkPac. So this was a fairly common labour hire structure within the mining industry. So the mines tend to supplement their permanent workforce with labour hire employees through businesses like WorkPac. And so Rossato worked for WorkPac, so WorkPac was his employer, but he worked within the Glencore business within a couple of their mines. In response to Rossato coming forward and asking for his permanent employee entitlements, WorkPac went off to the federal court seeking declaration. So you've got the ability to go to the federal court to seek certain kind of things, and these were declarations in a couple of areas. Like, first and foremost, that he was a casual employee, So they wanted it to be declared that he was a casual employee, and essentially that would require something of a departure from scheme, although some of the circumstances were slightly different. In the alternative, that they were entitled to offset payments made to him through his hourly rate of pay against permanent employee entitlements under the National Employment Standard. So, you're paid a casual loading. That casual loading compensates you for your lack of access to paid personal leave, paid annual leave, compassionate leave, etc. So that was item one of the offsetting or the financial element to it. Item two of the financial element was that they were entitled to, or that they put forward that they had an entitlement to restitution, and that restitution is about that there was a mistake and a common mistake between the two parties to the employment contract as to its nature. So if he's declared a permanent employee, that was it was a common mistake for him to be deemed a casual, and they should be able to obtain restitution for the casual payments. The second is failure of consideration. So in any employment contract, there needs to be kind of offer acceptance, intention to create legal relations, and consideration. And the concept was that Rossato essentially did nothing to get the casual payment because he was deemed a permanent employee. That's the failure of consideration element. There was a 12-month delay after the hearing. Sorry, and I'll put the full court in June issued its decision. It was actually the second or third last day of May that the decision came out. And unfortunately for WorkPac, they were defeated on all counts. Rossato was held to be a permanent employee. There was no capacity for WorkPac to recover any casual loading paid to him and offset it against the permanent employee entitlements, either as a standard offset or through the provisions of a regulation that was passed by the government after, that was made by the government after scheme, or for this kind of mistake or failure of consideration area. So essentially, WorkPac lost on all counts, and we're on the hook for essentially 3.5 years worth of entitlements for Mr. Rossato, which was quite significant in the context of, you're looking at about kind of 14 weeks of annual leave in that 3.5 years. We go to the next slide. Thanks, Gareth. So in terms of the facts, I spoke before about the on-hire nature or labour hire nature of Rossato's role, and in the kind of on-hire labour hire world, you'll generally have an overarching contract of employment between the on-hire firm and the employee. Similarly to those who direct hire employees, they'll have a casual employment contract. The thing that supplements that in the labour hire or on hire world are these what referred to in a number of different ways, but I generally refer to them as statements of assignment conditions. So I'll call them assignment conditions, and those assignment conditions set out what is going to happen within a specific role that the employee is being engaged in. So for a lot of on-hire firms, they might only ever have one set of assignment conditions because they may only ever work on one assignment. Rossato worked on a number of assignments with WorkPac and at kind of Glencore mines, including a number where he was engaged for supposedly specific periods. So there were, the length of assignment was generally put at somewhere in the 6-month phase, but could be extended, wasn't guaranteed, etc. so it looked like as you go through the decision, it looks like that WorkPac after skiing identified that there was a problem with the structure of their assignment conditions and entered into a new set of assignment conditions with Rossato, particularly in, I think it was for the very last of his periods with WorkPac. And what they'd done is really respond to some of the scheme findings, which were, you know, that the casual loading wasn't specifically identified, and that it wasn't clear that the employee could accept or reject work at their will. So some of the facts that I thought were quite critical to the determination of his employment status. He was provided with the mine's rosters. So basically, the mine would say, you know, shift A, shift B, shift C. You're going to work on a 2-week on, 2-week off, 12-hour at a time shift, and that's the mine shift. And rather than WorkPac giving Rossato his own roster, they just said, here's the mine's roster, and that's what you'll work to. He was working in the same type of role, side by side with their direct hire permanent employees. He worked almost entirely in accordance with those rosters. There were some kind of breaks in it. I think there was a period where he made himself unavailable for a few days because I think it was his partner had suffered a health issue. There were a couple of instances where the mine shut down for a short period, and he didn't work during those periods. But apart from that, he was working fairly strictly in accordance with that roster. He had to get to the mine and back. So rather than a fly in fly out, he was a kind of drive in drive out worker. He was based in Queensland. I think it was about 2 to 3 hours, depending on which of the two mines the assignment was at. He drove in and drove out of that, provided with accommodation for his 2-week swing. And the contract, I thought the judges probably put this a bit higher than it actually was, but it was almost like there were penalties for him. You know, the risk of termination if he failed to work in accordance with a roster that he accepted, or worked in accordance with an assignment that he accepted. And it's these factors that really caused him to be deemed to be a permanent employee. If we just go to the next slide, there were some critical things here that go beyond what happened in skiing. First and foremost, though, the most central kind of consideration, the most critical question that came up in both skiing and Rossato is this concept of casual employment not involving a firm advance commitment as to the work that will be performed. So if you're the common law definition, the reason this got to where it did is that the Fair Work Act has definitions of casual employment in some areas, but not an overarching definition of what a casual employee is. So there are trigger points for casual employees to get certain entitlements around parental leave, around access to unfair dismissal protection, but there's no overarching definition of what a casual employee is. And the NES contains all of these provisions that apply to permanent employees and do not apply to casual employees. So there's essentially a gap in the legislation, and so that allows the court to apply kind of common law principles to the idea of what a casual employee is, and that was the real risk here, is that, or the real issue here is that, you know, casual employment is this kind of as needed ability to accept and reject work, no ongoing commitment to long-term employment, essentially a succession of kind of individual engagements. And the problem for WorkPac with both Rossato and Skeen is that there were these really long forward projecting rosters. There was no real engagement with either Rossato or Skeen in relation to the hours that they will work during the assignments. There was no kind of ability to accept or reject shifts. And so it was really difficult for WorkPac to successfully argue that Rossato was anything but a permanent employee because of those really long advance commitments. But what the decision did kind of beyond Scheme, so I mentioned that there was a regulation that was passed, and that was a decision of the Attorney General to try to provide a solution for employers to prevent this sort of risk arising, and that was that if it essentially said or provided for the entitlement to offset. So it would mean that if you were a casual employee, paid a casual loading, if an employee claims payment of NES entitlements in lieu of, or for payment in lieu of taking those entitlements, then the individual or the business can offset the casual loading that was paid against those entitlements. The full federal court gave that a really kind of harsh slap down, and in a kind of triumph of verbal gymnastics or linguistic gymnastics, has said that what Mr. Rossato was claiming was not payment in lieu of those entitlements. What he was asking for was those entitlements. And so it kind of defeats regulation 2.03A almost in its entirety. Now we had our reservations about that regulation anyway, because for one, it's almost entitling someone to cash out the entirety or be paid instead of the entirety of their annual leave entitlements or personal leave entitlements, and that's not permitted under the Fair Work Act. So we had some doubts about it anyway, and I think the government just saw it as a bit of a band-aid solution. Ultimately, it did not work, and it really means that it's very difficult, even with a good offsetting clause in your contract, to resist a claim for payment for entitlements under the NES. Claim of restitution was roundly defeated, and the change to the contract it was from the fourth assignment. The change to the contract wasn't enough to override the other provisions. So that fourth contract contained some of the provisions around, or fourth assignment contained some of the provisions around, accepting or rejecting hours of work, but it was kind of inconsistent with the overarching contract. So what does it mean? It probably means that there's not a lot different from Skeen, save that a couple of the things that had been I guess hoped for as solutions have been knocked out. One thing that it definitely doesn't mean is that casual employment is done for. There is still absolutely a place for casual employment. I think what it has done is to highlight some of the problems with long-term and almost kind of business strategy direct casual employment, in that if you are running with a part casual workforce, and you're doing it directly, but that casual workforce is just essentially permanent by any other name, then you're open to some of these risks. But casual employment is still a valid area. I think what does it mean? There are, I think I said there are about 18 class actions currently on the go. There's a group called Adero Law, which intervened in this Rossato case, which has probably the most significant of those actions. And they are at the moment predominantly around the mining industry, black coal mining, obviously, where Skene and Rossato both came from, are a hotbed for this. But we don't think that's the end of it. We think that other industries are likely to come under scrutiny. It's reasonably poor timing because Victoria's recently implemented changes. I think I've probably put it a bit higher to say that they promote class actions, but they certainly make Victoria I think, the most attractive jurisdiction to commence class action. So we absolutely expect that this will extend into other industries. I thought that manufacturing and distribution are probably a couple where there's a little bit of risk. I think there's a number of white collar areas where some of these class actions might arise. There are, we've got a number of clients who either engage directly or are labour hire on hire providers who have casual employees who work for very, very long periods of time in very, very stable roles. I think one of the interesting and probably concerning and in an odd way, probably quite helpful in terms of getting some sort of legislative change, is that one of the users of these kind of long-term casual employees are state, federal, and local governments. So I think that's one of the reasons why we're sitting here going that they might be motivated to make some change. I think what else it means is that without a legislative change, and that most likely comes through a casual employee definition in the Fair Work Act or a completely successful appeal, the risk for businesses who directly engage casual employees on an ongoing, consistent basis will remain. So that will still be here. But bearing in mind that the risk lies with the employer. In Skene and Rossato, you don't hear anything about. Well, you hear small things about the host employer, but all of the risk and all of the liability lay with WorkPac and not the host employer. So we've been working through, and we certainly did after Skene, and we've had another look at it after Rossato. If you are engaging casual employees, it is helpful to have a contract with them, a written contract, and a written contract that really promotes the idea of casual employment. So, you certainly want the casual employee and its purpose identified. It's in lieu of paid entitlements, other associated benefits of permanent employment. Provides you with an offsetting entitlement where an employee is deemed permanent, despite the fact that this has probably been knocked over in the Rossato case. It is a defence, and it is a valid defence, and with the likelihood that there'll be some sort of legislative activity, I think it's quite an important defence. But probably most importantly, the contract fully supports casual nature through the absence of a clear commitment to ongoing employment, clear right of the employee to accept or reject work that's offered to them. So if you have in a contract a provision that says there's no guarantee of hours, you have the ability to accept or reject hours offered to you. It's a tough one because it can be something that doesn't really work for you operationally. You actually might need the casual employee to be quite reliable and quite structured in terms of the hours that they're going to work, but you need to have that level of ability to move the hours around. and for the employee to say, no, I don't want to work at this time. It's that's all well and good, but probably the more important thing is the way that hours are communicated, offered, accepted, etc. If you are engaging casual employees and you engage them on a weekly or fortnightly roster, the ideal scenario is that you communicate out an offer of a roster each roster cycle, and that casual employee has a means of has the knowledge that they can reject those hours and has a means of you registering that they have accepted those hours. So that rather than a kind of set and forget model, it's an ongoing offer and acceptance of hours, and in that way, it becomes less important whether the employee's hours varied at all during the employment. The most important question is, did that employee have the ability, if they wish to reject those hours? That's your kind of ideal scenario. And if you can implement, that's great. But this is less important if there's if your casual works variable hours. If you've got someone who's filling short-term needs and does so on a kind of seasonal basis, you're generally okay. It is sensible to do some form of a risk audit for yourself. We've done this as some general kind of propositions, but if you have a look at your casual workforce, see who's worked more than 6 months. That 6 months isn't a deciding factor, but it gives you that kind of, because let me withdraw that. That's not a determinative factor, because a firm advance commitment can happen within the first 5 minutes of a casual engagement. If you're in a skiing or Rossato situation where the first thing you get is a roster that projects forward 12 months, and you've got a assignment condition that says the assignment will be for 6 months, although this is not guaranteed and may be extended, you're probably immediately fitting into a permanent employment consideration. But 6 months is a reasonable yardstick of how long someone might be with you, where that risk might arise. Now, they've worked in the same role at all times, no or very little role in communicating hours of work, and the hours of work are not subject to any, or subject only to a small amount of fluctuation. And that's in the number of hours, start, finish time, days of work, all that sort of stuff across the period of service. That's how you identify which of your casual employees might be at risk here. In terms of the next steps, WorkPac's appealed the decision to the High Court, and the process in the High Court is that you first need to apply for special leave. They run at about, I think, 1 or 2 out of 10 cases that apply for special leave are given special leave. A large number of them are knocked over. So that's a fair hurdle to get over. Although this is, I think, that because of the significance of this case, it's more likely that special leave will be granted. Attorney General's confirmed the government will intervene in the appeal. I say they're in support of WorkPac, really in support of the idea that a casual employee paid a casual loading shouldn't then be entitled to another entitlement. Same time, as I said, the government's flagged the issue of casual employment as one of the areas of legislative reform, set up a working group of employer and union parties to discuss how best to deal with the issue and to try to reach some sort of agreement about that. In materials filed by WorkPac in support of its appeal, puts the potential cost of the decision at upwards of 15 billion. Sorry, that should actually be just below 15 billion. I think it's about 14.6, 14.8 billion that they've put it at. That is based on some ABS data. It makes a number of assumptions on that data, some which might potentially overstate the cost across the economy, but in other ways potentially understates it. So the data on which it's based only goes back 5 years. There's an absolute that employees can claim up to 6 years payment. As most of you on the call would know, that's the kind of limitation period for underpayment claims. There is, though, an argument that it can go back further than that, in that the entitlement to the payment in terms of annual leave, at least, doesn't arise until it is sought. So, you know, as an employee, you can take no annual leave for 6 years, 7 years, 8 years, and then kind of seek 32 weeks of payment if you're an ordinary employee on a 4-week per year annual leave accrual, and that entitlement to payment doesn't crystallise until it's requested. So there's probably an argument that it's higher than that amount that WorkPac's put in its application for special leave. We can go to the next slide. So we've put it there at timing of change, because I think it seems from the things that the government's been saying publicly and their involvement in the Rossato case in particular, they have they see this as an issue that needs to be resolved. They've made it clear that they want to implement changes, broad changes across the industrial relations framework to protect the economy and promote employment and promote the journey out of the significant economic crisis that we're in at the moment. And the cost of deemed permanency is seen as a significant risk to this. So, you know, if the cost of this is anything like $14 billion, that is way too high for the economy to bear at the moment. That's what the government really is talking about here. And I would have thought that even if it was 10% of that, and perhaps even 5% of that, you know, you're still looking at kind of $1.4 billion to $700 million at in the times that we're in. You know, the government can't be seen to allow that sort of cost to be placed on business, because it's a handbrake to recovery. In terms of the process of what they're doing, these working groups are scheduled to meet between now and the end of September. The government's hope is that they will result in some agreement between unions and employer groups that will then make the path to legislative reform easy. So what I think what the government's hoping for is that out of the working group that's dealing with casual employment, is that the employers and unions will come up with a way of resolving this issue that provides kind of a bit of protection either way. If that agreement isn't reached, it does appear that the government said publicly that we can't get agreement and we think the change is important, we'll push through it. And you know, I think their aim would be to have something done by the end of the year. Timing for the High Court special leave application and appeals unclear, but I can say with almost certainty that there won't be an outcome in that this year. It may be in the first half of next year at best. That ends my presentation, but we've got some questions, Wayne.
Thank you, Nick. I appreciate that. And thanks for the presentation. We'll transition quickly into the Q&A and work off the Q&A section there. But I'll kick things off with a question. Nick, a lot of our audience who are employers of a casual employee workforce will be thinking we could be forced to pay large sums of leave entitlements. What sort of legal trends have you seen other than the two decisions that you've discussed today that allows us to gain some insight into that?
Yeah, I mean these two decisions are the continuation of a kind of consistent, I think, set of decisions that look at what casual employment is. But they're looking at leave entitlements specifically, and that's a really kind of important thing to note, because there are other things that can create risks here as well. Like you can have people engaged under awards who have different permanent or casual entitlements that for things like loadings and penalties, where deemed permanency might actually attract some of those additional entitlements as well. I think there is a pretty significant risk here for a lot of businesses around that ability for employees to claim both the casual loading and the leave entitlements, because the legislation is really clear. It's permanent employment, and there are very strong restrictions around the way that you can contract out of those entitlements, and that's where this offsetting thing becomes a problem, because if the NES says you must take annual leave, you can only cash out a certain amount through a written agreement, all these sorts of things. It's very hard to argue that the casual loading is being used to pay that, or can be used to offset it, because you might have a compliance with that regulation that was made, but be contrary to other provisions of the Fair Work Act, and place yourself at risk of penalties and things under that. So that's the other thing, that it hasn't really come out in either of these cases, I don't think, is that some of the things that have been done are essentially breaches of the Fair Work Act that come with potential penalties for the employers.
So just as a follow-on from that, Nick, there was a question in our Q&A from Howard Powell. So thanks, Howard, for the question. Appreciate it. And it sort of relates to my initial question. He said, what about the Justice Buchanan decision that came after Skene, where a casual was claiming paid leave after 10 years of employment, and the judge said there was no changing of the employment engagement, and he was therefore prepaid and compensated for the paid leave entitlements. Are you aware of that?
Yeah, I mean, I think those circumstances were quite different to the Skene and Rossato. So I think the great unknown with this, I need to be clear about this. The great unknown with this is how far and how many casual arrangements this extends to. There are the continuum of casual employment goes from work for a month, never required again, to work like a Skene and Rossato type person, and across that divide, there's an enormous breadth of types of arrangements. There have been decisions of the Fair Work Commission, and they're not entirely helpful because they're not a court, but there have been decisions of the Fair Work Commission that have said that the award says you're engaged and paid as such. If you're paid a casual loading, you're a casual employee, and that's the end of the argument. That's what Fair Work Commission full benches have said. In the casual common issue case in the award review, the full bench of the Fair Work Commission was in a lot of ways quite critical of the Skene decision, but it's almost they can be, because they don't they don't make decisions about entitlements. No one goes to the Fair Work Commission and says, I want my permanent employee entitlements. They can raise disputes, and the Commission can make decisions on disputes, but those aren't binding as payment things. And so, it is very difficult to depart from the reasoning in Skene. It's even more difficult, in my view, to depart from the reasoning in Rossato, because it is such a comprehensive decision. 3 separate decisions issued, each of them dealing or focusing slightly differently on some of the main components, but I think it's made any other decisions, particularly decisions of single judges, very, very, very difficult to rely on.
Just keep moving in terms of the questions here. We've got a question from Janet. Thanks, Janet. Thanks for joining us. It was dealt with within the presentation, but there's an opportunity, I think, to delve just a little bit deeper here. The question is, Nick, that what if they're a casual employee of a labour hire agency, and for instance, in this case, Symmetry HR, and not on a casual contract with the business itself, so the host employer? Do these risks still apply, and how would you sort of describe the landscape there?
Yeah, well, I mean, they certainly apply, because that's exactly what the WorkPac model was. So the risks apply, but they apply, unfortunately for you, Wayne, to Symmetry rather than the host. And so you take on the responsibility for making sure that the things that you're doing are consistent with casual employment. And in a lot of ways, that's easier for you to do than it is for the business itself, that's managing a permanent workforce and a casual workforce who are working kind of side by side, doing in a lot of instances the same role. I mean, I had an experience where I worked for a labour hire firm in a factory back in my young days, and was there for probably 4 months, working side by side with direct hire permanent employees. Was taken on by that company as a casual employee directly, and after another 3 or 4 months was taken on by that employer as a permanent employee. The risk lies with the employer. So in my first 3 or 4 months, it was the labour hire firm that carried all of the risk. In the next three or 4 months, it was the direct employer that carried that risk. And I think that if I look back at that scenario, and it's well beyond 6 years, mate, so I can't claim anything, but I was doing, I don't think anyone contacted me at any point beyond the first shift to say, Nick, here's your roster. It was, mate, turn up at 7, clock off at 3:40 or 3, whatever the time was, to get your 7.6 hours, and you're locked in. Those are your hours. So I think those kind of models can be challenging. And yeah, as I said, the kind of risk follows whoever the employer was. But if you've got that model, you've got kind of 3 different sets of employment that really look like they're the same for all intents and purposes.
Mm-hmm. So, look, moving on to our next question, Nick. A lot of our employees in the audience today heavily rely on the casual employment model, whether it be for managing seasonal productivity increases or performance assessment as a casual before commitment to permanent employment. So that sort of links into a question from Miles Scott, and thanks again, Miles, for your question. Is it possible to compel a casual employee that's been determined to have effectively changed to being a permanent employee in the course of their employment to accept a permanent contract?
Yes, I guess you're asking if they can be compelled to accept the permanent contract, or if they can be compelled to say that, well, that's accepting the difference between casual and permanent employment.
Yeah. To sort of, Miles has sort of specified this even further. Can you have a clause in the contract that if determined to have changed to permanent, that there's the loading will be removed, that they'll be deemed to be a permanent employee from a date, that's communicated to them?
Yeah, it's a really fascinating proposition, Miles, because it's kind of addressing one of the risk factors with Rossato and with deemed permanency, because you are putting a clear line and really establishing the casual loading, but you might also be almost acknowledging a firm advance commitment, which is kind of on the entire other side. It's an interesting one, because I think it was in Scheme that Scheme was probably the WorkPac was probably arguing, well, what can we do? We can't direct people. One of the problems that's out there is that there are casual conversion clauses. Those casual conversion clauses give an employee the opportunity to take up casual employment, or in a lot of instances require them to be offered casual employment. And the take-up level's really, really low because people don't want to give up the 25% loading. So, that you put that argument before the court, and their argument is, well, you should have brought the employment to an end, or taken away the casual loading and treated them as a permanent. So I think I'd have some concerns about that approach, Miles, because I think it's got some kind of risks around. You're potentially framing the arrangement as being ongoing and leading to permanency, and they're probably working in an almost permanent way as it is. I think the seasonal, the other category is this seasonal category that you referred to, Wayne, and they're the least at risk, I think. If you've got people who, you bring in for, and it may be that it's not kind of 1 or 2 seasons, it might be 4 or 5 seasons in a year. If you bring people in for short bursts of high volume work, and then you either dial them back to 0 or dial them back to a few hours, then they come and meet the next seasonal challenge and work a lot of hours, that's a casual employee. And I don't think that any employee who's working under that model could successfully claim that they're a permanent employee, because if they're working those variable hours, there has to be some sort of communication with them about those hours, and there has to be an offer and kind of acceptance of that. So I think that's the safest model. The riskier model is that kind of transitional employment.
Okay. One from Angus here. Thanks for the question, Angus. It's what is the best way to mitigate the risk if there's long-term casuals in the workplace today, and short-term and long-term? You did say in the presentation, Nick, around review and 6-month casuals, and use that approximate time frame. How would you advise Angus there and our audience?
Look, I think you need to have a look at the way so identify who's in that kind of risk category, so the 6-month and reasonably consistent hours, and have a look at the way that their employment is structured. Look at their contract, look at the hours communication, and if there's if there's no communication of hours, or if the contract doesn't support the casual nature, and this is where it's you're balancing kind of trying to address this risk with maybe alerting people to this risk. Is do you implement new contracts, do you implement new kind of hours communication structures in order to prevent being held liable later, but knowing that might, for a small cohort of them, have them going, well, why are they doing this? Like we've worked this way for kind of 1, 2, 3 years, and no one's asked about it. And now I'm being given a new contract that tells me I can refuse work. I've never been able to refuse work before. You've got to kind of balance those up. But I think you really need to look at each situation, and to be honest, people need to get their own advice about this, because it is a really challenging kind of area, and you want to balance protection of your business against kind of creating hysteria within the workforce. And I think in at least, I would expect in at least 50% of circumstances, the risk is going to be either very minimal or zero. And as a business, you might take the decision that we're just going to fix things moving forward. We'll kind of let the risk that's been there kind of hang around, and the government might change things and that might fix it, but we'll make sure that we don't bring no one else gets on the bus, and hopefully the government does something that pushes people off the bus in terms of that risk. So that might be the approach that's taken, but you've got to run that assessment and then get some advice about what the best steps to implement are.
A couple of questions just to finish off on, because we're almost on the hour. This one's from Ian. Thanks, Ian. This one sort of relates a little bit to how much heavy lifting is there in relation to to managing your own casual workforce? You know, would you put it in the heavy lifting category? For instance, you know, what is the recommended process for existing long-term casual employment tenures? You know, is there things that you can put in place and initiate, like amendment to pay slips, the way the hourly rate is broken down between base perm rate and casual loading, and a number of other. You know, you've talked about roster management techniques. You know, would you put it in the heavy lifting category and you know, comment on some of those strategies?
Yeah, I think it's people hate when I say this. It kind of depends, but I think where the risk is highest, the lift is highest. So you know, if you've got a relatively small number of employees that you might think are in the risky category, and the risk around them is kind of medium, then you might just implement some of those things that you're talking about. A payslip that separately identifies the entitlement. You might reissue a contract if it's not entirely clear about the casual component. You may you know, just over time, you might adopt a process of over time shifting from no hours communication to a kind of really compliant, what I'd call compliant hours communication structure. You might kind of do that in a couple of stages. It can be, I mean, if you haven't done it, anything that you've got to implement that you haven't done before is a reasonably significant administrative lift, because you have to put some sort of system and process in that makes sure that you're doing it at each time. Because it seems simple to say, well, okay, we just need to make sure we're communicating our hours with our casual employees, but you know, how are you communicating, and how are you tracking that it's being communicated? How are is tracking that they've accepted that? It's, you know, the administration depends on whether you implement a system that does it, so like a time and attendance system that does it, or whether you're trying to manage it yourselves from an administrative perspective. And that again depends probably predominantly on how many and how much you need to use it.
Yeah. Just a couple of quick ones to finish on. Just a question from Jade. Thanks, Jade, for the question. Really appreciate it. I can probably answer that one in relation to how does this work for labour hire agencies. And as Nick alluded to in the presentation, WorkPac and Glencore, the host employer, the liability sits with the labour hire agency when the casual employee is employed by them. So you've said that, Jade, you don't have any casuals under your books, but have regular agency casuals working for you. My response to that would be that the agency that you use is the one that holds the liability in that particular space. So I want to move on to the final question here, which I think is probably the most apt one to finish on, Nick. What is your expected reaction from the government? I mean, you alluded to it a little bit before, but just to finally finish off with the last question, keeping in mind, everybody, that all questions will be directly answered if they don't get mentioned live on the webinar. So, what is the expected reaction from the government in your view, Nick?
Look, I think that you can tell from the fact that the government's, you know, been involved in the Rossato case, so intervened in the Rossato case at the full federal court level. It has indicated that they will intervene at the High Court level. That they acknowledge this as a problem, and I think the what we call a gap in the legislation, which doesn't provide a definition for casual employment, is the problem that probably needs to be filled. And again, I need to be a little bit careful about what I say and make sure I'm not revealing anything that's outside or that's not within the public domain. But that all that stuff is within the public domain. I expect that there will be a definition provided for. The problem though, Wayne, with any definition is that, you know, it's a great thing about hiring lawyers, mate. They'll find a way around that definition to pin you down. So we'll need to look very carefully once that definition is presented. You know, and the hope would be that the definition is something along the lines of, if you're paid a casual loading, you're a casual. And you know, that might, I mean, to get to that level, you might need some additional protections for employees. There might need to be some kind of greater access to casual conversion. As I said, I mean, I work with a range of clients in a range of industries, and casual conversion is probably one of the least accessed entitlements that I've seen. So we have clients who are trying to convert people to permanent employment, and those people are saying, no, don't want it, not interested. I want my casual loading. I like both the casual loading and the fact that I don't have to commit. If I want to take time away, I can take time away. And if that, even more than, so we have a lot of clients who say, well, can we get someone to sign something that says that they don't want casual conversion? And I say, it's not going to stop them being deemed a permanent later. But if you capture the reasons why, and if one of those reasons is they like the ability to be able to reject work, then they're kind of acknowledging and helping the court decide whether there's a firm advance commitment to work. Because for that person to be able to say, no, I'm not coming in on Tuesday because I want to do something else. I want to go and do some different type of work. I want to study. I want to spend some time with my family. I want to do some social activity. Then that's casual employment. So yeah.
Absolutely. Well, look, we're looking at the time. We do need to wrap it up there. We're a couple of minutes past 11 o'clock. I want to finish off on a couple of things for our audience in particular. By participating and registering today, you will receive a Symmetry gift pack, which will be the recording of the webinar sent directly to you. That will include the slide deck as well. There's also 1 hour free consultation on this topic as it specifically relates to you and the company that you represent. Also, there'll be 5 free online employee COVID-19 health checks to monitor the health of your staff during these times. And finally, there'll be some recruitment discount vouchers from Symmetry HR as well. I want to thank Nick Tingley. Thank you, Nick. You've been brilliant. It's great to share another educational webinar with you. We've done it a couple of times now, and I've enjoyed it every time. So thank you very much for your time. It's much appreciated. To everybody out there in the audience, enjoy your Fridays, enjoy your weekends. To all your families, please be safe, particularly those at the moment in Victoria. Yeah, good luck to everybody. Be safe, and we'll talk soon. Thanks very much. Bye for now.